Welcome back, ladies and gentlemen. Now we have a panel discussion on deciphering the commercial and cross-border litigation 2022 and beyond. This session will discuss provisions in contractual agreements which can act as the first line of defense in cross-border litigation, the rise of environmental litigation in the wake of increasing demand for sustainable growth, e-discovery and case management softwares, next-gen tools for next-gen litigation, and many more important aspects of the cross-border litigation. Now I would like to invite Richa Pathak, Group Vice President Legal, Avigna Private Limited, to lead the discussion. It's my pleasure to invite the co-panelists, Charanya, Lakshmikumaran, Partner, Lakshmikumaran and Sridharan, LNS, Payal Khanna, Director, Legal and Compliance, Volvo Cars India, Prarabdha R. Jaipuriar, General Counsel, SUEZ India, Sameet Gambhir, Vice President, Corp Law and Company Secretary, DCM, Shriram Limited, Yogesh Wadhwa, General Counsel, Hyundai Motor India Limited. Welcome everyone. Over to you, Mr. Pathak.
Hello, everyone. At the outset, I would like to thank ET to organize Economic Times Legal Leadership Conclave 2022 and inviting us to share our thoughts on this commercial and cross-border litigation 2022 and beyond. The rapidly growing and globalizing corporate world has given birth to multinational entities that surpass national boundaries, creating an almost borderless relation among several businesses. Almost every country has commercial relations that extend beyond one or more jurisdictions. Now, why the focus on cross-border litigation? The increasing globalization of business has inevitably resulted in a dramatic increase in the number of litigated disputes where the parties are based in different jurisdictions, or there is some other international aspect, such as the location or the evidence or the assets. Such disputes, of course, raise particular legal issues, many of which fall within what is traditionally known as private international law, such as jurisdiction, the choice of law, the enforcement, the recognition of foreign judgments, and so on and so forth. For commercial parties dealing internationally, an awareness of developments in those areas of law are important as a key part of dispute risk management. Not only when a dispute arises, but also at the deal-making and contract drafting strategies and the stages. The rapid increase in globalization of all the sectors in the Indian economy has brought in a wave of massive and enormous changes to dispute resolution mechanisms in the country. Further, India's move towards direct data access agreements, the use of international cooperation mechanisms to balance efficient data access with protections for citizens' privacy remains a relatively unexplored facet of its digital strategy. Given the limitations of the existing cross-border data access arrangements, several countries have started looking towards alternative bilateral or multilateral arrangements to facilitate the data access. The COVID-19 pandemic has surely turbocharged the industry transformation and perhaps particularly propelled law into the digital age and reshaped its landscape drastically. With this particular understanding in mind, and we have few topics touching upon the key areas of thus deciphering the commercial and cross-border litigation and beyond. The sections over here would be covered, and the sections comprises of different topics, which are A, contractual agreements and cross-border litigation. Point number 2, discussion is harnessing AI and embracing future of legal. Delineating the legal tussles with respect to the enforcement of foreign judgments and cross-border litigation matters. Strategies to achieve cross-border data transfer in light of highly divergent legislations across various jurisdictional, territorial jurisdictions, the rise of environmental litigation, and lastly, the most favorites of the GCs, the GC's perspective on the commercial viability of litigation through modern issues of legal framework and regulatory practices. So we have to present the discussions on various topics we have on the panel with us. Mr. Yogesh Wadhwa, the General Counsel, Hyundai Motor India Limited. Mr. Prarabdha R. Jaipuriar, General Counsel, SUEZ India. Ms. Charanya Lakshmikumaran, partner, Lakshmikumaran and Sridharan. Mr. Sameet Gambhir, the Vice President, Corporate Law and Company Secretary, DCM Shriram Limited. Ms. Payal Khanna, Director, Legal and Compliance, Volvo Cars Limited. So just to begin with, I would like to first pose the question, which is falling under the topic cross-border litigation. Mr. Sameet, I would like to ask you a few questions, which begins from the cross-border related litigation practices. Many a times we have noticed that the step of active due diligence is often ignored and or missed by the parties. The reason being quick closure of the deal and consummation of the transaction. How do you think this can be explained and made aware about the repercussions attached to it? Over to you, Mr. Sameet.
Thanks, Richa, and thanks, everyone. So I think you're right, Richa. Invariably, I have seen asking, and Charanya can witness this, to litigators also, what should we have done actually to avoid this litigation? So we ask this question very frequently whenever there is a, particularly if a litigation is very high costing, or it's a very long litigation, then we really realize that what should have we done actually to avoid this. And that's where I come from, that point that the perfect due diligence is absolutely required before you actually go for a transaction, particularly cross-border transaction, I'm telling you. So we have really seen this, that this really helps not only to avoid litigation at many times, but also to make it a cost effective as well. So I think it's really, really important. And we normally, what happens is, and generally even when I go for a contract negotiation also with the parties, I generally say that we have basically two opposite party to negotiate. One is that the person I'm dealing with, I'm negotiating the contract with the other party. The second, in-house of my business person also at times. The business people sometimes, to you GCs or you legal people, they give you so much of the pressure to close the deal. This is something my bread and butter. This is something that, we need badly. And Sameet, you need to do this, you need to do like that, negotiation. So, they try to brainwash me in such a manner that, okay, I said, nahi, yaar, ye to deal khatam karke utna hai aaj, So that is what is something, we have to be very, very careful. My point is that if I need proper indemnity, I need proper liability clauses, I need proper due diligences to be done. So it has to be done properly. I really can't agree to, because I'm not paid to, for the business. You may be getting your salaries because you're getting good business, but I am paid to take care of the risk for the organizations. My duty is to take care for the organization that you are risk-free, you are least disputes are expected, least risk is there. So I think that's the reason we suggest that a proper due diligence is very, very important, depending upon the kind of deal. For example, if it's an M&A deal or it's something else, some other business transaction, have you really seen their contracts? Have you really seen their executed contracts? If there is any liability which is coming towards, which can convert into future dispute. Maybe, have you actually seen their IPRs? There could be some IPR related issue, and then you don't know what is happening. Some employee related issue, you don't know what kind of a litigation could be there tomorrow, So all kind of a contracts, all kind of a IPRs, all kind of a liabilities issues, insurances issues, local data privacy related issues. I don't know, so much issues. So whatever legally, typically we do in a due diligence as lawyers, I always suggest that one has to be very, very careful in that. And I think you're absolutely right. Due diligence is absolutely required to avoid litigation in future.
It is. In order to be aware of the risk, as well as to make others also aware about the repercussions.
Absolutely.
Yeah. Mr. Yogesh, would you like to say something on this?
I was just going to add here that while we can do all the possible due diligence, and it's very, very important, as as a GC, that's our role, to avoid any kind of unnecessary risk to the company at large. But given the way Indian courts have been actually dealing with the issues, that itself opens a Pandora box for us a lot of times. As a typical lawyer, we try and avoid any kind of disputes, but we want the deal to be successful. But we always have a dispute resolution clause to safeguard our interest. So while that being said, it's there, specifically when it comes to any kind of a cross-border kind of litigation, that itself is a big issue. We might be choosing our place of forum, we might be choosing a place of jurisdiction, arbitration clauses could be there. But the way, say, a foreign party also perceives our Indian legal system, the uniformity of the civil procedures, the way there have been contrary kind of judgments in the past, specifically, speaking about the Bhatia international case or say the ONGC pipes, these have been setting various kind of precedents for the way the courts have been interpreting any kind of cross-border kind of agreements which have been executing. And, having said that, there have been so much of kind of penalties also which have been imposed on various kind of parties. We have one of the cases of white case judgment, which under the bilateral investment treaty, there was a penalty which got imposed because there was so much of a delay in having a kind of sound and reason kind of a judgment over the years. It took almost 10 years to reach a conclusion. So while those kind of challenges are very much there, I think we also need to bear all these things in mind while drafting any kind of agreement.
Absolutely. All the nuances related to the dispute resolution mechanism also has to be taken care of, apart from other provisions under the contract. That's true. Thank you, Mr. Yogesh. Thank you, Sameet. Now, the key requirement in regards to the contracting parties is that the financial soundness and the position of the other party is not checked many a times. That is what the experiences of various different GCs are. Is not checked by the contracting party before entering into the such cross-border contracts. So to what extent do you think it is true? I mean, if you can, throw some light on this, because many a times even I have experienced the financial soundness of the company who's investing is not actually we have not done a proper due diligence for the entities, for the clients who are, where the investments are being made in that particular entity. So something related to that, if you can throw some light.
So if I may come in on that.
Yes, Brad. Yeah.
Richa, so thanks. Based on my limited experience in contracting, I would say that if I were to draw a list of common errors, this would probably on the top of my list.
Yes.
And sometimes it's done deliberately. As Sameet said, business interests are often, they are in a hurry, so they try to ignore that, and sometimes in genuine oversight as well. And I will share the perspective from my business. SUEZ is in the business of executing projects in water treatment and water distribution and things like that. So we do a lot of municipal contracts. So the government clients, they have a very tough process of client evaluation, contractor evaluation. So technical, financial, all these due diligences are very tough with them. They ask us to submit a lot of document and information and supporting documentation, etc. So, and then after that, the price war is there. So it's always a race to the bottom. And once a contract is awarded, there is always a kind of a hurry to get on with the project and kind of cover up, maximize the gains somewhere in the subcontracts. And in that rush to maximize gains in subcontracts and vendor selections, the mistakes often happen, and especially so when the vendor is not an Indian party. So if we are procuring an equipment with commissioning services from a foreign equipment supplier, or if it's a civil works subcontractor, even civil works subcontractors can be an Indian party or a foreign party, and a proper due diligence is not done, financial soundness is not checked. See, if there are many harms which can be caused. Of course, the possibility of such subcontractors or vendors not performing is relatively much higher than of a vendor which has been properly vetted. And then when such a non-performance happens, even the courts would probably not come to your rescue, because they will say you did not perform your duty of caveat emptor. So you kind of lose your legal defenses to some extent as well. And then I'll give one more example. In limitation of liability clause, we generally provide exclusions, that if some disclosures have been made or something that we have discovered during due diligences, we will not limit liability on that. So all these clauses will not protect you if you have not done your due diligence. And then, of course, when the non-performing parties steps aside or subcontractor steps aside, all the consequences from the main contractor main client start to flow on the main contractor. It can go as bad as a blacklisting, of course, termination, liquidated damages and whatnot.
Absolutely.
And then if you want to onboard a new subcontractor, that new subcontractor knows that your bargaining position is very weak, so you end up shelling out more money. So you inflict damage on yourself from many sides. So I would rather suggest that this financial due diligence should be it would be an activity which should be co-timed with the tender process itself, so that you save time there. You can probably end up creating more profiles than you need, but still that's a better situation than to have a vendor which is not vetted at all.
No, that's true. That's true, Mr. Prarabdha. Very well said. I can completely, yes.
Maybe Richa, and also, I still remember, I was working with an organization which we were into risk mitigation and all.
Okay.
So I think we used to get a lot of assignments from a very, very big Fortune 500 companies. They were dealing with their clients and, just to do the reputation check of an individual or a financial check of an individual. And plenty of time we have seen it, that there's a pattern in the human being also, and we have really we have found some people actually, when we see that there has been some pattern or they're in the habit of doing some non-compliance or default, but not in this deal, or maybe not with this party or any other party. So I think they have really clearly they have the level of doing them that no, we cannot do business with these people because they have already done some kind of small labor related. So I think reputational check, background check, this is also plays a very important role, particularly in the cross-border litigation, I think.
I agree with you, Sameet. I agree with all the points what you have just highlighted and touched upon, as well as what Mr. Prarabdha has said. I completely agree. It actually creates a very domino effect if one particular link is not taken care of, and it actually falls down. And at the end of the day, it's all about the reputation of the company which goes into suit, which I completely agree. So hence, financial soundness of the company has to be diligently done, an exercise of all.
So Richa, I like to slightly give an input also on that. It's not totally on the cross-border part, but I think my fellow colleague Yogesh will agree, because we come from the same automobile background.
Yes.
And, especially it's more, lately we have been seeing, we have these dealers across the country. And the COVID situation coming in, it has made us rely specifically, in the auto industry, that the financial stability and discipline of, even if it is for our local dealers, and our local parties, is also very important, and in fact, I've lived through it through my entire period here, that, how business teams now, frankly speaking, are putting a lot of emphasis of, when they are appointing a new dealer partner, just to check that, he is financially stable, number one, and then completely, on a regular basis, they monitor, his financial stability. And not just that, in all, our contractual arrangements, we have, made it as an important performance parameter, for our dealers, workability. So I think not just cross-border, which is, of course, the brand reputation is, but for you to be a successful and, a business partner, even domestically, now it's gaining a lot of importance even within our country. So, and I think we as lawyers, have a key role to continue to, harness this fact to the business teams.
Very true.
So that's, I'm giving you a live example, which I've been living through it currently.
I know.
No, I think, Payal, I think you're right, because I think, on a lighter side, I'm saying is that because of the lawyers you are sitting on the automobile company, now, the dealers have stopped doing the credit services for the car servicing and all, because we used to get a lot of cars or our company to the dealers. Now they say, no credit, please. Our legal has advised us not to do servicing and everything on credit, because Corona, there is no future now, no tomorrow. Today we are working, tomorrow there's a lockdown and all. So everyone is so scared now. Just on a lighter side, I'm saying.
I agree, Mr. Sameet. Yes.
Thank you, Payal. Thank you, Payal, for sharing your experience, the live experience. The indigenous experience, I would say, in regards to the domestic experience as well as the cross-border. And I completely agree, it shouldn't be only limited or restricted to the cross-border transactions, but at the same time, the domestic usage also. And it should be applicable in the domestic part also. Coming back, so Payal, as we all belong from the legal industry and based on our indigenous experiences, the profession itself, the legal profession itself is highly driven by the concept of decision-making, analytical reasoning, analysis, and representation. So the automation of which is, I'm sure it's unattainable. So what do you think, in your view, in regards to the practices you have been involved till date regarding the e-discovery and the case management software, which is the next generation tools for the next generation litigation? Over to you, Payal.
Yes, so I have been sort of, have had the experience of, automating to that extent, litigation management tool in my earlier organization where I was working, because, it all again came up with the pains we lawyers feel. And, when you're joining an organization who's already burdened with legacy cases, and you don't have, a clear visibility of where to start and where to stop. The documents are all over the place. Since I was part of the large organization, which had multiple regional offices across the country, so it was very difficult, how do you manage and understand what happened 10 years back in the particular case. And also I feel now with the COVID situation where all of us worked from home for most part of the year, I think these sort of tools have created a lot of their importance, because you don't have recourse to the physical files. So I'll be honest, while the legal aptitude, the legal skills continue to remain, but I think these tools have a very important role to play now, to at least bringing a lot of legal efficiencies, because earlier we were, a lot of dependent on the physical paperwork. But I think with these tools, we can not just, have an easy access, but, it also helps us at creating a central repository, because at least you have easy access. Secondly, at least I'm giving you my own experience since I did handle some, tax matters in the past, which have very complicated, calculations and everything. So, and over a period of time, the interest rates keep on increasing, and, you need to depend on the finance team to do the calculations, and the lawyer, your external counsel is asking you, what is the stakes involved.
I agree.
So I think we automated a lot of those mathematics in the tool through the AI efficiencies.
Okay.
And we as lawyers could just simply download a report from the tool and find out exactly what is the stakes involved. So I think given that, it just enables us to do our job better. So I am a big supporter of all these tools, while of course we still have our traditional ways of working as lawyers.
If I can just jump in there and add to what, yeah. So while Payal has excellently summarized, the pains that in-house counsels and GCs face, we are a largely litigation-based office, right? So we handle huge amount of litigations, and now we are handling it over 14 offices and things like that. So we have now also, actually for the last 5-6 years, we have an excellent litigation management system, which we keep upgrading every couple of years, depending on what is the latest technology available. And we have actually, COVID actually was not a very great impediment for us, because all our files were digitized. There were very, I think only 5% or 10% of our files which were not digitized. So overnight, we just had, access, online access, our, the notices, investigation, appeals, our compilations, everything had been digitized, and there are these different packets in different, under different IDs, and that has really helped. And the other thing now that we are trying to do over and above this, because both for the consulting division, the advisory team, as well as the litigation team, over and above this huge database that we've internally created, we are now applying AI tools on that to try and map similar litigations, to try and map a certain position that we have taken as an organization, and try and see if some synergies can be achieved there, to ensure that we are not saying something different to two different clients. So that is now, I think that's the next step. So I always feel we must embrace technology. It is here to stay. We cannot be an ostrich and say it will go away. It is here to stay. And I know, the older generation of lawyers used to know the citations by heart. And, I think all of us in our initial few years of, of practice have been under that immense pressure to remember citations, to remember case laws by name and citation. But then, because of search tools, because of these lovely tools that we have access to, we have freed up that space in our mind. We know the propositions, we know what judgments are there. And then we freed up that mind to do the next level of value add. That, okay, now that this is available, what can I do next with it? So I think as human beings, as professionals, we will evolve. So I'm very, very...
I agree. I agree with you, Charanya. It's like two sides of the same coin. One side, yes, we can accept me or myself being a lawyer as well as the GC of the company. I am also from the law firm background. So yes, I completely agree how efficient and how quick we have to be and how prompt we have to be when it comes to the mandates, what we receive from the clients and how quick they are and everything. They just consider it's just my matter with you. It's you who have to do it, no matter how you do it. But obviously that despite the threats and limitations, what AI is also pose, I would not say it's completely risk-free. It doesn't have the disadvantages, but the AI is here to witness the future growth, which is sure to outshine the disadvantages, and it is surely to emerge as the facilitator of efficiency and productivity around. But on this other side of the same coin, it is here to seriously hamper the cognitive processes also and the critical thinking of the human being in the human minds in the long run. Yeah. So what matters the most here, whether it is is this an approach which is going to sustain for long? Your thoughts on this? Maybe Sameet can also, pitch in.
Yeah. So Sameet, why don't you go in?
Yes, sir.
So I think you're right, Richa, because we are at a stage wherein no one is clear that what is going to happen tomorrow. Everyone is embracing the AI. Everyone is embracing technology. Technology is really, really helping us. And that the things are moving fast. We have seen in Corona that this has really, really helped us. But you never know what is going to happen after 20 years down the line and all, because ultimately, is AI killing our creativity? That is the question. Is AI, making us a little, what I would say, lazy or different in our thinking? Because ultimately, आज की date में, even if you think that, because we are of that generation which we have seen both the eras actually, but you never know what will happen when there will be new lawyer who has not worked anything on the books and who has only worked on the AI and all. Up to what extent they can use their brain power or their creativity?
That's what my point is. Yes, correct. Because I also, if I go back to my experience in my real estate long back, I remember referring to Tijori Wala.
Right.
Tijori Wala for drafting in the solicitor space, for drafting the real estate conveyancing transactions. Gradually, nowadays the freshers and the kids, they don't know what Tijori Wala is, whether that even existed. So I can completely agree with that point.
And
I'll share. Sorry.
Yeah, sure, Yogesh. Yeah, please go ahead.
I was just going to share an experience here. So I was speaking to a friend of mine who practices in London, and he mentioned that the kind of AI tools they have that can actually predict that if the matter goes before a particular judge, what will be the outcome of that proceedings and what is the outcome of that particular litigation.
True.
Wow.
Well, that's
I was pretty skeptical that how successful that will be. Possibly Charanya can vouch further on this if you'll have
I can vouch that it is bound to fail in India. This is not work at all.
Yes.
There is no guarantee. There is no guarantee to this.
No, but people have started asking the litigators now,
Yes.
On the basis of their AI tools, do I have a good case or not? This is a very normal question nowadays. And look at the contracting side. Particularly for the litigators also, I feel really good, that when there's a lot of data they have to collect and make out a case or a contract and all, it really helps you to streamline the thing, what is important for you, what is not important for you, what is relevant for this case, what is not relevant for cases, which are the previous litigation, which are the previous cases, everything they can quickly gather.
Yes.
But this is what is is happening actually, but I don't know what will happen 20 years later, when it will be really dangerous for us or not. That's the important question.
We are yet evolving and touching upon a lot of other areas.
In fact, in litigation financing also, we have seen a lot of use of AI in litigation
financing. On the basis of that, they are deciding it actually.
Exactly.
Addiction, yes.
Yeah.
But my only concern, and maybe it can get expanded over time, is that when we are using AI, say for contract drafting, prediction, etc., there's always going to be a chance, etc. But when you're using it, say for contract drafting, now the problem is that when certain contracts are made, and this is to answer your original question, Richa, that what about our competency, right? Every clause is pregnant with meaning. Now, over time, what happens with several amendments, the types of contracts, there's a lot of copy pasting that happens. You sort of lose the sense as to why the clause was put there in the first place.
Correct.
These kind of issues. So, which is why you can't, rely on AI. It is almost like relying on, the junior most person, because he's not going to have context. So that intelligence still has to come, and really that's going to be the crucial value add.
That's true. So now, very well said, and it's really brainstorming session on the AI, and we can just go on and on and on. It's really a favorite subject I can see here. But now since data is involved in this discussion, so Charanya, the discussion now, I would just take it to some other level, to a different level. The discussion of the government data access are primarily closely intertwined with the need for greater transparency, oversight, and accountability, and the government's ability to access citizens' personal data. So a rethinking of the Indian legal framework on these counts has, particularly become very necessary in light of the Supreme Court's verdict in Justice K.S. Pattaswamy versus Union of India case, which recognized privacy to be a fundamental right. May I know the progresses made in this case, and if you can please address these connection with the same thing?
Absolutely. So thanks for the question. I was involved in the Pattaswamy case myself. I was assisting the Attorney General. Yeah. I was on the other side. I was a government lawyer for a few years, and I assisted the Attorney General. I was in his chamber. So both in the 9-judge as well as, which is just right to privacy, and then the 5-judge, which is the, validity of the Aadhaar Act, certain sections of the Aadhaar Act. Now, what the Pattaswamy judgment says, I just want to take a minute and explain what the judgment says.
Yes.
And thereafter, what it directed the government to do, the kind of framework that was necessary, and then the progress that was made and where we are stuck. And I'm using the word stuck with all, responsibility. So the 9-judge Aadhaar, the Constitution Bench judgment, first said that a citizen has a fundamental right to privacy. It is linked to your right to life and liberty, right? And if by way of a legislation or by way of governmental action, let me put legislation secondary, but by way of governmental action, if personal data of an individual is being forced to be parted with, so if I'm being forced to part with my personal data, then that is a violation of the fundamental right of privacy. That was really what was held. So then they proposed a three-step test or a threefold test, which is there was a case of modern dental, which was then affirmed in the 9-judge Aadhaar, which is a test of proportionality, that there should be a law, that there has to be just and reasonable cause, and the restriction should be reasonable in nature. So there has to be a law, there has to be an objective, right? As to what is it, why are you infringing on an individual's privacy? What is the objective you are seeking to achieve, and the means that you're using to achieve? So assuming the objective is, say, traffic management, but you are trying to get an individual's data, entire day's data, with his personal ID, everything, that amounts to surveillance. That doesn't amount to, so can you achieve the same traffic management as your objective with means that are lesser than this? So can you get anonymized data? Can you get metadata in order to work on that without affecting an individual's right of privacy? Because the harm that is caused can be so great if there is a breach. Now, in this background, while they upheld the few sections of Aadhaar only to the extent of, this public delivery system and for, the Manrega and rations and things like that, they did caveat it, saying that, India does need a proper framework. Today, we don't have a framework. Very frankly, we don't have a framework. You have the IT Act. You have, with respect to personal data, there is no real protection. You don't have a right as a citizen qua your personal data, except for sensitive personal data. And there are some 2011 regulations that are still operating. Post the Aadhaar judgment, Justice Shri Krishna's committee was constituted. And in 2018, they gave a proposed PDP, or the Personal Data Protection Bill 2018. And that got revamped in the year 2019, where you got the PDP 2019. Now, both of these are modeled on GDPR, which is what is there in Europe. And there is a lot of modeling on the basis of GDPR. Now, this went to the Joint Parliamentary Committee, and last year, the committee gave a report. And in the interregnum between 2019, that is sending it to the committee, and then the report being generated by the committee, there has been discussion about non-personal data. So personal data, the kind of treatment that personal data should be accorded, and non-personal data are wholly different. But what has happened is that now there is a Data Protection Bill 2021, which merges these requirements of both personal data as well as non-personal data. It's sort of a combined effort that they have done. I keep hearing, I don't know if these are rumors, that they're going to rehash this and come up, junk this and then come up with a totally different bill. I don't know. But what I do know is that industry is suffering with the lack of clarity. And why it is suffering is because just imagine the number of multinational companies in India, right? The kind of data transfer that is happening, between the Indian company and the foreign, group company. Look at the quantum of information that the Indian subsidiary or an Indian company is collecting with respect to employees. A very simple example like employee health insurance. Now, health data is a sensitive personal data. And if our PDP bill comes into effect, you can't, you need prior approval if you want to send this information abroad. And they're probably going to have some sort of a back office which is going to process this, etc., etc. Now, that's a mess, right? Now, we are not saying don't do it. We are just saying, give us clarity what you're going to do and when you're going to do this. So there are multiple issues, and largely, if we are going to talk about brick and mortar companies who are MNCs, they have already enforced GDPR. A lot of them are in some sort of a lull that the Indian bill is very similar to GDPR. There are variances, at least 2-3 major variances. So unless we have clarity over this, industry for the last 3 years has been on the brink. Do we do this? What do we do? Do we plan? Do we have a compliance officer? This is all that, and frankly, people are tired now. So we hope.
I know there has to be some breather now to understand and to, I completely agree with you. And I've made few points also, which according to me, I think, based on your points, the objectives and the means to achieve, and yes, industries are suffering. So I think India should, set up a multi-stakeholder task force to formulate a model on international agreement on direct data access through an open and consultative process. That's what I think now. Based on what the discussion.
Absolutely, at least so that you have categorized certain qualitative data, and then you say, irrespective of when your legislation comes, irrespective of this thing, at least there are some standards for transfer of data, which is not going to cause much harm and which is required for sort of a day-to-day functioning, which is not going to be misused by companies, but they need it for regular use,
Thank you, Charanya. Thank you. Now, since we discussed so much on data transfer and data access, I think the next important topic is delineating the legal tussles with respect to the enforcement of foreign judgments in regards to the cross-border litigation matters. So here, Yogesh, I would like to ask you, a question, which is we all know that Arbitration Act is broadly based on the UNCITRAL model law. And India has certain reservations under the New York Convention, which can be found in a Part 2 of the Act under Section 44. So it will be really helpful, Yogesh, to discuss the various reservations imposed by India under the NYC, as well as if you can throw some light in regards to the Bhatia International case, where Supreme Court ruled that the Arbitration Act applies to international commercial arbitrations held outside India, which you can discuss a few points under the study.
Thanks, Richa. I think I'll start with very brief kind of a thing. When we speak of the Arbitration Act, it's divided in Part 1 and Part 2. And while Part 1 specifically deals only with domestic arbitration enforcement, Part 2 speaks of the foreign, arbitral awards to be enforced in India. And wish things were so simple like this, and where courts don't go beyond that. But normally, what we have seen that leading from various kind of interpretation issues and the way courts have exercised their jurisdictions. Specifically, when it comes to Part 1, I think primarily on 3 angles, they still interfere quite a lot. So there have been various precedents where the court has said either the arbitrators were not competent, cases, let's say, fraud, where the courts felt that it should not have been referred to arbitration, or the most prominent one where the courts held that it's in public policy that I should interfere.
Against public policy.
And this is, the most famous case of ONGC versus SAW pipes also.
Yes.
So when it comes to Part 2, which is specifically on the foreign arbitral awards enforcement, specifically coming to the Bhatia International case, the court held that even the proceedings, which had happened outside India, they have a right to interfere unless Part 1 jurisdiction has been excluded specifically. So there have been scenarios where the courts, despite the fact that the parties specifically agreed to, litigate outside, they had the, forum chosen appropriately, they have chosen the courts outside, they still said, no, this is in public interest and, the public should be protected, so I'm interfering. Now, for all reasons, yes, this was very much challenged, and the Bhatia case was overruled in 2016, wherein the courts held that despite the fact that Part 1 has not been specifically excluded, the courts should not interfere. So that has been a little bit of history, how the courts have really progressed over the years. But I think still there are contrary positions, coming from ONGC case still, where there are challenges. And while, when it comes to the reciprocal kind of jurisdiction, so coming from the New York Convention, which India is still a signatory, there are still many countries which are not part of that reciprocal kind of arrangement. And that itself creates a challenge. So countries like, say, China, I think Hong Kong, they are still excluded from the reciprocal kind of arrangement. So if the two parties are, choosing a forum which is based in any of the excluded kind of jurisdiction, enforcement is again going to be challenged. And last on my list, the courts have been even holding that where the two parties litigate outside India, but they are Indian parties, courts have been exercising jurisdiction on those cases also. So I think it's different conflicting kind of reasons, progressing definitely, but still much more clarity is yet to come.
Thank you, Yogesh, for throwing some light on this. Charanya, I understand in this landmark judgment of Ramanathan Chettiar and another versus Kalimut Pillai, the court has detailed the circumstances in which the foreign court is said to have competent jurisdiction. As we all know, the different circumstances set forth by the court in the said judgment. Just in order to have a better understanding and a very comprehensive understanding of the foreign court's competent jurisdiction, could you please explain us the basic tenets of the same in the said judgment?
Absolutely. So when we are talking about enforcement of a foreign award or a foreign judgment in this largely, what happens is, it's a two-step process. First you need to get your the decree or a judgment from a foreign court, which itself is, it's a huge task.
Yes.
And thereafter use that and get it enforced in India. So this is a two-step process. Now, when a foreign judgment is sought to be enforced in India, there are, of course, many methods. Some can be treated as a decree itself under Section 44A. We don't need to get into that. But the first argument that defendants usually take is that the award is bad, or the judgment is bad in law. Okay, and so this judgment of Ramanathan Chettiar versus Kalimuthu Pillai is an important judgment to understand what are the grounds on which it can be decided. I don't want to say alleged, but can be decided whether the foreign court has rightly entertained the suit or not. That is really, it's one of the steps of passing through.
Basically, adhere to the merits of the case or not.
Exactly. So it talks largely about jurisdiction. So this is typically in an argument that one takes to say that the foreign court either had the jurisdiction or did not have the jurisdiction to pass that particular judgment. And really this is in that realm. And I know there are about 4 or 5 principles that have been laid down in terms of jurisdiction, etc. But for simplicity, we can put it in 2 large buckets. One is that the foreign court had jurisdiction to entertain the suit and, pass judgment in that case based on residence. And the second one is called a submission doctrine, that the parties submitted to that jurisdiction. So these are the 2 main buckets, right? So when it comes to residence, it says either they are carrying out business in that particular jurisdiction or they have residents of that jurisdiction. Now, I have to confess that this threshold of residence is a much higher threshold to sort of, get past. Even if you look at, books like Dicey and Morris, and the judgments referred to in that very case also, they say that the threshold for proving residency, proving that somebody was actually, doing business in that area, because largely you have cases where there is an agent or you're doing business through a third party, so they don't really have residency. So those issues are difficult to prove. And we've seen that systematically it becoming difficult to prove. But the second bucket, which is submission. So that's a very interesting thing. And that's really where courts do look at, I think I can see traces of that even in the Amazon future emergency arbitration in the High Court. These were some arguments that were taken. Not entirely on this basis, but you can feel the thing of it. So if the plaintiff or let's say the defendant here against whom, or the judgment debtor you call, if he has submitted to the jurisdiction of that court, and this evidence can come through various reasons or various facts. One is he has gone and appeared in that court, says, appears in that court, argues, and then loses. And then he cannot go and say, no, they did not have jurisdiction. Other thing is contractually, if this plaintiff, if the defendant here or the judgment debtor here has actually entered into contract and he himself gives himself the power to sue in that country, in that jurisdiction. Thereafter, he cannot say, I may sue in that jurisdiction, I cannot get sued in that jurisdiction. So, these are the 2 doctrines. One is the residence doctrine and the submission doctrine. Really, courts, I feel, in the past so many years, it's a very old, 100-year-old judgment, but the submission doctrine, the threshold, as I said, it is easier to prove. You can prove by conduct. You can prove by contractual terms. You can prove by other disputes that they have, participated in that jurisdiction. So this is really what, this judgment says.
Thank you so much, Charanya, to throw light on this. And I completely agree, the submission doctrine as well as the resident doctrine, and very well explained. We could now understand a lot deeply this particular judgment.
Thank you.
Thank you. Thank you so much. Now, just a different topic we will be taking up, which is the environmental litigation. I would like Prarabdha to answer this question. So, which is the economy and ecology go hand in hand as necessary catalysts for building a model of sustainable development of nation. In India, environmental litigation has played a significant role in shaping up this relationship. So, Prarabdha, could you please throw some light over this? Over to you.
So, thanks, Richa. Of course, all of us have read that one case law. I would say several case laws with the same name, thanks to the great lawyer, Mr. MC Mehta. So, he made our job easy in environmental law. So, any citation Charanya was talking about when she was speaking about AI, she was talking about how we had to memorize citations. So, at least this was one paper where memorizing was not a great challenge, because every citation was MC Mehta versus Union of India. So, on a serious note, we owe a lot to him, because in India, he started off a series of reforms, I would say, in environmental law, which were ahead of the time, for a country, for an economy, which was still at in nascent stages of development. It was quite likely that we would not have paid that much attention to environment, because growth, development was a priority. But his interventions made sure that environment got its due attention. And of course, we have moved far along in that journey. And now with NGT, we have a dedicated body looking at environmental claims or environmental issues. Of course, pollution control boards, etc., are also there. But from adjudication point of view, NGT has played a great role, I must say. And I see a trend kind of evolving with NGT. Almost every sphere of pollution, whether it's solid waste management, hazardous waste management, river pollution, air pollution, noise pollution, NGT has either itself got involved, or because of interventions by NGOs and public-spirited individuals, environmentalists, NGT has a role to play in that. And NGT ends up not just passing one-off orders. It sets up a monitoring committee, an oversight committee. It goes into the topic. Sometimes it takes years, but they do detailed study. They do follow-ups. And then we have seen that for hazardous waste management, for example, the detailed report that they have published, probably it's a good literature to read on that topic. If you want to start to know the hazardous waste segment in India, probably the good document to start is the NGT monitoring committee's report. Similarly, Yamuna pollution, or even the monitoring committee that they have set up for that. So all these things, the involvement of NGT and for that matter, other courts, also Supreme Court and the High Courts, in various matters, whether it was a Taj trapezium matter, or the Aravali mining case, and so many other cases. I can, in fact, CPCB set up the rule for coal-based power plants to install FGD units, flue gas desulfurization units, to reduce pollution. And they were given a lot of time. NTPC, the public sector enterprise, was kind of ahead of time to complete those assignments or those installations, but private power producers were lagging behind. Matter went to Supreme Court. Supreme Court took a tough view and rejected their application. So you see so many such cases. In Maharashtra, for example, you see that a lot of environmental clearances have to perforce go through a process which is administered by, or not administered, I would say, which is overseen by the Bombay High Court. So it kind of eliminates the additional risk of the matter going back to a court, because it has already been examined. Of course, it may slow down the process a bit, but at least you prevent further delays coming out of that. And there is a greater assurance that there has been a good oversight on that matter. Now, even for this sewage treatment, which is one of our mainstays as a business, we see that the Supreme Court and NGT and the High Courts have taken a very strong view of the pollution. If you look at Bangalore, the froths coming out of the Bangalore ponds and water bodies were known all over the country. There were fires in the froth in those lakes, and then court took a strong view of the matter. Penalties were imposed, and escrow fund was set up at the order of the court, a tribunal, to facilitate treatment of sewage going into the lakes. In fact, there is a different order which has kind of imposed penalties on states and municipalities for not treating sewage and discharging them directly into water bodies. So all these cases, right now, there is one case which is that now the Supreme Court is seized of the matter, which is about the effluent norms or treated effluent norms for the sewage treatment. There are several large treatment plants to be set up in Mumbai, and the Supreme Court has said all the matters related to that should come to us. No other court should entertain those, so that we can speed up the process. So the sense of urgency that you see, that the courts have kind of infused in this environmental cause, that is really something which is heartening to see, and it has really played a great role in improving and in fact bringing us at par in many cases with developed nations. There is still miles to go, but at least we are moving in the right direction.
That's very true. Very well said, Prarabdha. Thank you for sharing your experiences, and I completely agree with the case law, the famous case law of MC Mehta versus Union of India, which was ahead of time in regards to their decision, and the interventions had environment considered. That is how the environment was considered a significant topic and a significant status what actually was granted to environmental impact as well. And NGT has definitely played a very major role in addressing all these issues. And United Nations SDG goals are of 2030 is here to play a lot of actual sustainable goals in the environmental assessment and the environmental impact. Thank you. Thank you so much, Prarabdha. Now, last questions for all these GCs on the panel. What is GC's perspective on the commercial viability of litigation through modern issues of legal framework and regulatory practices? I would like to have each GC on this panel, as well as Charanya's observation from this point of view of GC's perspective on the more commercial viability of litigations and all.
I think as in-house counsels, we keep on, I think Sameet also quickly touched upon that, we always ask the question that what we could have done better, to avoid this litigation. I think that's something question we all get asked.
True.
I think to my business folks, small mess, my answer is that, litigation is inevitable, especially in a country like India. You will do your best, do all the things possible, to try and mitigate legal risks. But I think our judicial system is such and is so democratic that I think we still will end up into litigation.
Some or the other litigation.
Some or the other. Having said that, I think what is very important is that, when you are going through the whole process, which finally you feel that we're going to end up in litigation, how best you can, make your processes, your documentation robust, that, in case you have to defend the case in the court, how best you can, defend it, number one. Number two is, and I also, again, go back to my business, whatever litigations we had, in our organization and all the companies I've worked in is, we have a lot of reflections, and a lot of learnings out of those litigations. And I still remember during my role in PepsiCo, when we had so many litigations across the country over 25 years, we bracketed, the kind of litigations and why those litigations are happening. And, and I'll be very honest, and we understood that there could be some litigations which were there because the law was unclear, like a typical classification dispute. There were some litigations which happened because of the ethical dilemmas. So because, we work in an ethical organization, and obviously we had to do the right thing. And there were some litigations which were happening due to process gaps, which we improved over a period of time, and we did not have at that time. And then there was also a fourth quadrant, which was purely like a legal stuff. So, I mean, I think from a GC perspective, while there are costs attached to litigation, and lately, we do see a trend that the company encourages you that what we can do to settle the matter, what we can do to, avoid it. But I think I always, have the view that we can do the best, but whether we can avoid a litigation is something which is not in our hands. So that's my perspective to this.
I think I'll second what Payal said. So, sitting in the industry where both of us are, on an average, I get almost 10 to 15 complaints every day. While we are always looking to improve our processes, being a very customer-centric kind of organization, we try and see that how we can satisfy the customer. Still, every day there's a new complaint which keeps on multiplying. And that could be because of a lot of awareness among the people, be it consumers, be it, say, any of the dealer, or be it any third party we normally deal with. Everyone is very much aware of their legal rights. So that cannot be avoided. Yes, we need to look at a position where we can try and secure ourselves. I mean, today we might be sitting on any big kind of a contract, which could be with an international party, and tomorrow the services are not served properly. I'm going to litigate, protect my interests. And similarly, the other side will have its own right. There could be a competition issue, there could be taxation matter, it could be a plethora of litigations. So as rightly said, we need to see that when we look at any kind of a contract, we need to secure our best interest. Yes, we need to find balance with the business requirements also, but that's the way to go. We can't avoid that, work around and see that, we are keeping it to the minimum from a financial kind of exposure. That's the best thing to do.
So I think from my perspective, you must have heard that, when you start a relationship, or particularly in a marriage or other relationship, you say that you keep all your eyes and ear open, particularly. And when the relationship happens or the marriage happens, then, you have to close your eyes half. So what I'm trying to, explain here is that, before you get into a relationship, or, at the contracting stage or at due diligence stage, you have to be very, very careful, as if that, you have to avoid at any cost all litigation, and, you have to mitigate all the risk. But litigation happens. It's a fact. And, kisi na kisi ko, someone's to get benefit out of the litigation. That's the reason they do it. And once the litigation happens, then perhaps, you have to see the relationship from a different angle. You have to see whether actually, one is that, can you really get into kind of a compromise? Can you really get into a balanced approach? We have really seen that, if we think that litigation is required or may not be required, that's something the call has to be taken. So at times we have seen that, okay, let's settle it, because ultimately litigation is not going to help in this matter particularly. So at times you have to take a lot of calls on that. And, once you are into litigation, then my approach is a little different, that let's try to settle it. So why waste time and energy, and, nothing but the lawyers are going to earn out of it. So sorry, Charanya, for that. But I think a little balanced approach has to be taken as a GC, I'm saying, because you need to be a business enabler, and then we say at that point of time.
Absolutely.
So I think
a true business partner to the company.
Yeah.
Over to you, Charanya.
So I deal with a lot of GCs and tax heads. So typically the 2-3 questions that we hear are, is it necessary? Do we have a case to argue, right? And then question is, case to argue doesn't really stop at the level at which the litigation starts. Do we have a case to argue till the Supreme Court? So that is a very, very important aspect that has to be analyzed at threshold stage. So that's very important for you to keep those data points in place whenever a litigation starts. That because inevitably in India, be it private litigation or regulatory litigation, we do see matters dragging on and reaching the Supreme Court in some shape or form. So that is one thing. Second, of course, is the time. So there is a time versus effort versus, cost analysis that needs to be done. If it's what we typically engage with GCs and try to help them make these decisions is this a one-time issue? Or is it something that you're going to see year on year? Okay, is it a one vendor issue? Or are you going to see this with 4 other vendors so that if you settle with one, then 4 more will come? So those are real business decisions that they take. But then we help them that, whether the interpretation is correct. So those are some of the things that we help them make those decisions, right? Finally, in terms of time, while with respect to, so as I said, two buckets, very, very large buckets, regulatory, where you have competition, you have electricity matters, you have, tax issues, etc., where really it's not in your hands, it's a fate. As my previous boss, Mr. Venugopal used to say, "Hane bara." It's a, Kannadiga word, which means it's in your fate. If whatever is written, it is bound to happen. But you have very less control in terms of deciding whether to go in appeal or not. Because even if you succeed, and I'm sure everyone here has faced that, success at a tribunal level or at a lower appellate level doesn't guarantee you closure. So the problem really is the lack of closure. It's not that if I get a judgment in my favor, very well reasoned judgment, the chance of it getting overturned is always there, right? So that is a very big risk factor. And that is something that I do see GCs grappling with. They're always second guessing, did I do the right thing by, going in appeal, or, should we have, so, and it's very hard.
In hindsight,
they do answers to that, right? Assuming they accept the decision against them, and they don't file an appeal, and 4 years later or 3 years later, someone else gets a similar relief.
Right.
And then, so those things you really can't help. Right. So, but the biggest thing is the cost. The fact that, and cost is tied to time, right? The number of adjournments in a matter, they are just innumerable adjournments. The bench will change, other side doesn't show up. Do we engage a senior, or, should a junior person appear? Case management. So those are real issues that, we try to help and give correct advice.
Yeah, sure.
To GCs.
Very much we can relate. We GCs can definitely relate to that.
Yeah, in fact, I quickly add a few points to what has already been said. I always, when I speak to my team members on this topic of our role as in-house counsels, I often draw analogy to a character from Greek mythology, Cassandra. So I say we have a Cassandra's curse. By our very training, we will make prophecies and nobody will believe them. And we have to live with that, because those will probably come true one day, and we will have that told you so moment which will not give us any happiness. So that's the kind of predicament that we live with. And that happens with in many cases. And then finally, when you reach a stage when you have to litigate, you have to litigate. And then there is no running away from that. So, of course, there is cost involved, there is time involved, there is uncertainty involved, which is the biggest, which is something that business never likes. And then if you have claims, maybe there are counterclaims, and then you have auditors. And so there are several things linked to it. And then in our business, tendering business, you have to disclose your pending litigation. You have repeat business from the same client. So you have to make a choice. And then it's not always an easy decision for a general counsel to kind of just announce that now I'm going to get into this litigation. It's not that easy. And I would say, thank God it's not that easy, because if we start going for litigation in all cases, probably it would be a nightmare for us as well. And then sometimes it's just a matter of choice. You make a choice because as a GC, I don't want to get into a battle. I have to choose it wisely. I just want, internally as well as externally. Internally, some stakeholders will probably not like me to get into that zone at that point of time. For business, maybe it's a battle to choose for some other day. We don't pick that battle today. Interestingly, we have to create that stakeholder engagement within the business. And the moment you are able to achieve that, interestingly, there would be people coming to you to file a case. That, see, this is a resolution that we are not able to get. Can you help us through a litigation, an arbitration, conciliation? I sometimes somebody walks in, I simply tell them, come to me with a BATNA. What is your best alternative to a negotiated agreement? Otherwise, there is no point having a conversation. I'm not going to get into this battle if I don't know that I'm going to win, or at least I have a probability of having a decent settlement. If we are on a completely wrong footing, there is no point picking up that fight. So of course, it's an interesting choice that we have to make, a difficult choice at times, but that is what our life is all about.
Exactly, that is what the role we play now. Yeah. So very well said, everyone. Just to summarize the points, so beginning with Payal, where Payal rightly mentioned, there has to be robust documentation, the safety nets in order to safeguard the position, in order to secure ourselves. The different quadrants, which are the ethical dilemmas, the process gaps, that has to be taken care of. Yogesh very well said, we have to do the best, whatever we can do in our capacity, and avoid litigation if we can, and in fact balance with the business environment in order to sustain ourselves in the company, as well as the strategies by the board members, which is formulated. Sameet very well said, all eyes and ears have to be open to the risk and disputes, and we have to plan our strategies accordingly, taking into account these important critical points. Charanya, I completely agree with you, Charanya. The data points have to be in place. Decide the threshold, and the time and cost analysis has to be the major chunk of it when it comes to analysis and examining the factors. And the matters a lot is the cost analysis and the time analysis, as well as the law firms are here to surely help us to avoid or reduce the litigation time frame and strategies. And if any litigation involved, the TAT actually plays a major role. And Prarabdha, yes, uncertainty involved, which is inevitable in any litigation. But yes, we have to consider and take into account the different considerations and interests of the different stakeholders involved in the company. Very well said. Thank you. Now I would just conclude the session. It was a very, very, very interesting, insightful, and very brainstorming session. I hope all the speakers on the panel had a great time discussing. I truly had a great time. So just to conclude, the importance, what I had just made a note of it while discussing, the importance of data access for law enforcement purposes is well recognized, as is the fundamental right to privacy. The current panel have well evaluated the ways in which India's present mechanism for lawful data access can be improved to achieve better efficiency in cross-border access while respecting the privacy rights. It highlighted several concerns with India's current laws and practices on data access, the cross-border litigation, the recognition and enforcement of arbitral awards, and so on, as well as the inadequacies involved in such processes. I would say initiatives and the reforms on all the fronts can and, in fact, ideally should be pursued simultaneously with the overarching goal of each one of us, with the mindset of improving the commercial and cross-border litigation, which in fact enhances the protection of privacy, growing India's digital market and the economic relevance for large global businesses, and strategic relationships with countries globally. Thus, with this mindset of continued economic liberalization, aiding with the help of the technological advancement, will definitely contribute significantly to the overall growth of the nation. With this, we wrap up the session, and thank you so much, each one of you on this panel. Thank you. Thank you, Charanya. Thank you, Yogesh. Thank you, Prarabdha. Thank you, Sameet. Thank you, Payal. Thank you, ET World.
Thank you, Richa, for conducting this session. Very well conducted.
Very, very enjoyable and wonderful session.
Thank you.
Thank you very much.
Bye-bye.
Thank you everyone for such an insightful and informative discussion. Ladies and gentlemen, do share this knowledge with your friends and colleagues on social media using the hashtag ET Legal Leadership 2022. Now let's move to the next session.